This is a great question from Quora. My LLC owns the trademark to the company name and logo. What if the company stops existing? Does the trademark stop existing also? My name is Andrei Mincov. I'm the founder of Trademark Factory. I'm going to answer this question in a second, but just so you know, one of the things we do on this channel is I answer questions just like this one all the time, right? It could be Quora, it could be from my email, it could be from Facebook, it could be from your YouTube questions. So if you have a question for me, make sure you post a comment below and I'll do my best to answer your question. And if you haven't yet, make sure you subscribe to get notified whenever the next video goes live. All right? So, okay, with that out of the way, here's my answer to this question. So the purpose of you starting a company, well, one of the purposes, whether it's incorporated company, a limited company, LLC, is to create a separate entity, right? And when it's a separate entity, it has its own assets, it has its own liabilities, it has its own rights. And one of those assets or one of those rights could be the rights in the trademark. It's the property of the company. And if the company stops existing, that can create really weird consequences because it may so happen that nobody really sees any value in that brand anymore except for the founder, but the founder can't have it because the company is already dead. And you look at the trademark pretty much as any other asset that the company may have, right? So for example, if the company owned a printer or a company owned, I don't know, books or computers or, cars, when the company stops existing, what happens with that property, right? So it gets auctioned to those who may have loaned some money to the company, to the government for taxes, all of that stuff, right? So that's what happens when the company dies. And in theory, if there's any value in the brand, that brand can be auctioned as well as part of the assets of the whole company, which is why it's important to understand how you want to deal with who's going to own that brand. Is it going to be you as the founder, or is it going to be the company? And it's important to have this figured out, especially if you've got multiple shareholders or multiple decision makers in that company in terms of who is going to end up owning the brand. And if you have not figured it out and the company dies, then in the end of the day, nobody owns it, right? And what you could do in case of a trademark, so if a trademark is registered in the name of an LLC that no longer exists, and you can prove that it no longer exists, you can request cancellation of that trademark. So what you would do is you would file that trademark yourself first, the same application, and then attack your old LLC's trademark to get that canceled on the basis of that the LLC that owns it no longer exists. So that's one way to do it. The other way to do it is through a contract to state that the brand reverts back to the founder one day before the company stops existing. It's a little bit of legal trickery, but it works as long as your creditors can't prove that you only did that to damage their ability to get paid on whatever you owe them. So if they see that you're just trying to divert the assets of the company and that's what you're doing with a brand, then this could be dangerous because they can go after you personally, right? It's called piercing of the corporate veil. But if you've done this long time ago, long before you had any issues with creditors, long before you had any issues with assets, then this could work. So be very careful with that. But to the short answer to your question is, if you haven't taken any steps and your trademark is owned by your entity, then it would die. It would die with the company. So the other thing that you could do in EOS is record what's called a nunc-pro-tunc assignment, which is almost backdating the assignment, because once your LLC is dead, in theory, nobody can sign on behalf of the LLC because it doesn't exist anymore. But there's a fiction that USPTO would recognize, and so nunc-pro-tunc means now for then. Basically, it allows you to file an assignment today for a date in the past, as long again as you can show them that there exists a valid reason for them to consider you having assigned that trademark to you personally, or maybe to somebody else at some point in the past. Now, I hope this answers your question. I hope it's useful. Make sure you like this video if it is. Make sure you comment below if you've got more questions, and make sure you subscribe to get notified whenever the next video goes live. And until then, I'll see you in the next video.